All right. Hello and welcome, everyone. My name is Marital Shah. I'm an assistant professor here at IBA Karachi. I teach law and governance, and I'm really excited to welcome a distinguished and currently geographically diverse panel. We have Nazish and Sara joining us from Karachi and Benazir joining us from London. So good evening and good afternoon. And I'm here in New York. So very good morning to anybody joining us from North America. My distinguished panel needs no introduction, but for the benefit of our audience, I'm going to introduce them. Sara Zaman is an activist, a researcher, an academic. She was formerly the director of the War Against Rape and has extensive experience of working with rape survivors. So welcome, Sara. And we have Nazish Brohi with us. Nazish is a researcher, an activist with decades of experience of working on gender issues. And I'm really thrilled that she was able to join us today. We also have Benazir Jatoi. Benazir is a barrister and a legislative drafter. She has most recently drafted a bill on violence against women. So we're very excited to have her here on the panel as well. And Barrister Minal Munshi was supposed to join us too. She has extensive experience of law in Pakistan. But unfortunately, she is in Beirut where the government has collapsed again. So we wish her well. And Nida Ali was also supposed to join us. She's an advocate based in Lahore, but she's had some health issues. Nonetheless, we're very pleased with the panelists who are here. And I'm excited to start this discussion on rape, law, and language. And I'm going to begin with some linguistic, sociocultural questions and then move on to the law. And the way this discussion is going to work is that there are going to be a few rounds where the lawyers on the panel, we've agreed that we're going to privilege the social activists and social workers on the panel, and we're going to ask them questions first before we move on to legal issues with Barrister Benazir Jatoi. So without further ado, I'm going to jump in to my first round of questions related to language and law. And I'm going to start with Nazish. And my question for Nazish is, Nazish, you've written fascinating articles about linguistic issues surrounding rape. I have also experienced some of those issues whereby I find that survivors that I've worked with find it difficult to find words in local languages to describe their experiences. So I'd be grateful if you could shed light on some of that work connecting law and language that you've done for our audience.
Thank you, Moriel. I think we may have first to kind of get a focus on what is the purpose of language. So, when you have these terms, they allow you to share an experience. So, if I say I tripped, or I'm hot, or feeling cold, or whatever it is, without me getting into explanation, that communicates to the hearer, to the audience, and they understand what it means. Now, the problem with not having a responsive terminology in the vernacular in Pakistan is that you actually don't have a framework for sharing experiences. What I mean by that is, if we look at the local words for rape in Urdu, or actually, that's true not just for Urdu, but for most of the languages that we use in Pakistan, they're all based on concepts of honor, the constructs of honor. For instance, izzat luti gayi, behurmati ki gayi, beizati ki gayi, abru chini gayi, hurmat, haya. These are the words that kind of feature in ismat. These are the words that continuously kind of feature. So what you do have is a rape victim, a victim of a violent crime, walking in and having to say that her respect has been robbed, and when I used to work on the front line of cases, I'd have to spend like the first few minutes actually telling them, is that like respect is something internal, no one puts it in you, no one takes it away from you, and respect is not an intact hymen. So And at that moment, that woman is in a very different place. She's not going to be able to, at that point, conceptually process these things, because it's the received burden over years and decades of not having any other formulation for communicating those experiences. And it also says something in terms of the media or our conversations, is how are we having these conversations in Urdu, where, and a certain amount of victim blaming is implicit even in our language, by saying someone ki uski izzat looti gayi hai. So you've already started with the premise that this woman has been fundamentally robbed of her respect, and therefore, what do you do with someone who no longer has respect? You don't owe that person any respect after that, because the respect is kind of gone. So, I mean, rape is now kind of has been circulated enough in our vocabulary to be able to selectively use it. So, sometimes the police will say it, for example, but for the average woman, there is actually no way of kind of formulating this experience in a way that can commonly be shared. We have legal things, for instance, zina bil jabra, but which woman is going to come and say that mere saath zina bil jabra hua hai, and it's, the language, it kind of permeates. So of course there's this overarching issue of not having, rape not being able to translate. I know that some groups have tried to look at alternative words. Some have come up with words such as zabarjinsi, but it hasn't caught on. So, how do you even create a language? I mean, rape, I guess, could be used. I mean, we can then kind of get into the problematics of where rape originates from, which is rapine, and it has a separate kind of connotation. But for our conversation, I just want to point out that it's actually not just this. It is in terms of, for instance, if you look at medical legal examinations, which rape victims have to go through. One of the things they do is they check the woman's vagina to see what level of injury there is or what elasticity it is. They use a 2-finger test, which they're not supposed to be doing anymore. But in any case, I'm talking about the MLO forms that we get with their assessment. And the language in that, for instance, a very common thing, which Sarah will also be able to talk about, is that they'll write, she's habitual. And that is their way of saying that she's habituated to having, sex, or she's been in separate relationships, or she's married, whatever it is. So then you have another linguistic thing where, a rape victim is just someone who's habitual. And look at the carryover baggage of language like that. In other things, I can tell you about this case in Dera Ghazi Khan, where a woman had been raped, but it was anal penetration. So she had been sodomized, but the police told the MLO that do this woman's checkup. She's been raped. The MLO writes, she's not been raped. And then we go back to her, and there was this whole thing, but she's like, but no one told me to check for sodomy. I checked for rape. So she just did a vaginal exam. And she's like, but no one said that. So it's not my fault. It's your fault. But the police is like, but it's the same thing. And she's like, no, for me on my form, they're completely different things. So like, a woman who's been raped then has to kind of explain the form of rape for even those examinations to be carried out and for them to be congruent. And this translates then into courts as well. So, the very famous case of Mukhtara Mai, one of the things that was held against her is in one of her earlier kind of testimonies. She said that when she was taken into this shack, this hut where she was raped, and then she had to come out naked. And so she was forced to come out. She like, mujhe nanga bahar bhej diya, ya mujhe nangi bahar gayi. But then when she had to say this again in court, she said that she went out without a shalwar because that had been torn or it had been thrown or whatever. She didn't have that. And then the lawyers picked up on that and said, well, you're lying, because one moment you say you went out naked, the other moment you say you went out wearing a kameez but without a shalwar. But for her, it's actually the same thing. So, what does the language mean? There was really no difference for her, and she couldn't even understand them kind of pulling these two things apart. And she's like, well, if I'm not wearing a shalwar, I'm naked. Like, whether I'm wearing a kameez or not is besides the point. But for the lawyer, it wasn't. It was a very different, legal point he was making. So, this issue of language comes up again and again. The legal language, more than me, it's very alienating. We have an activist in Hyderabad, Arfana Malla, and she often makes this point that by the end of it, all that's left is the shik. She's like, all the feminist arguments, all the experience, all that kind of leaves, and all that's left is the CRPC number. And that's the language that then kind of progresses, is what case number are you, what's the charge, section, dafa kaun sa laga hua hai, shik kaun si hai. So yeah, I mean, huge mess. I mean, I don't know where you begin kind of unraveling this. So does that begin to kind of answer your question? I can stop here.
Yeah, no, it does. Thank you so much for sharing that. I think that that added a lot of helpful perspective. And I'd want to, when I move on to the legal parts of this conversation, discuss the implications of the word habitual that you used, because I think that raises interesting implications, particularly in light of the recent, for instance, motorway rape case that we've seen, or in cases where married women experience rape, or even divorced women, or non-virginal women experience rape. How does our system sort of deal with that or not deal with that? And I think this is a good sort of segue for me to move on to Sarah, because in one of your articles, Sarah, that you co-wrote with Maliha, you had discussed this facet. And you'd also discussed rape as being a separate social category, almost from legal rape. And you had also written about the linguistic politics that takes place around rape cases. So I'd be delighted if you could share with our audience more about your work and research on issues related to language and rape.
Thanks, Muriel. I think before I get into the kind of things that are discussed in uh, that paper, there was a lot of background work that went into it. Of course, you've already mentioned that I worked with survivors and with the criminal justice system. And of course, a big part of the motivation to do this work was the kind of things that I would regularly hear, right, or I would read. So it was not just the text, of judgments and the text of what was said, but also the subtext, the meanings, the shared values and the shared meanings and certain common language, the value that they carried for the people who were saying it and the people who were hearing it. So, what Nazish was just saying, it just reminded me that, the word habitual, and then connected to that is the image of the woman with easy virtue, uh, and so many other things in medical legal examinations. They would write non virgo intacta, her virginity is not intact, or they would say things like the vagina admits so many fingers, checking elasticity, as Nazi just mentioned. So it is not just these kind of the kind of terminology, the kind of choice of words that you see, whether it's in judgments, whether it's in medical legal certificates, whether it's in the police investigation reports and the FIR. They obviously, all of these words, they carry meaning, and these meanings are then the things that we have discussed in the paper, are then the meanings that essentially are ascribed to those terminologies. Uh, Nazish, just taking up from what she has recently written about her article. I think, what was it, Nazish? What's in a word? Something like that. I was just thinking, what are some of the things that you continually hear from victims when they come to disclosing what has happened to them. And usually you find that it's not just the rape itself, but there's a series of different kinds of violations that have actually happened with that woman. So it's not just the first time round that she has difficulty, coming up with the right words, or coming up with any kind of words really to convey what has happened. You would hear things like, मेरे साथ बुरा काम किया, मेरी नाजायजी की, मेरे साथ जो है वो गंदा काम किया. Yeah, they wouldn't know exactly how to refer to a certain part of their anatomy to
Yeah.
describe really what actually happened. But then again, the problem with words, the lack of words, how do you communicate, it's also there then in the law. And I think that this is something that we figured that we might discuss today a little bit. The absences in law, in terms of the silence about, let's say, what is the meaning of consent, right? What does willfulness mean? What We don't have a word for incest. We don't have a word for necrophilia. There's so many things. Nazish has written about, I think, adolescence. So what we commonly hear in the field, or people say, they say कि लड़की जवान हो गई. Like, what is jawan exactly? When does javani actually begin? Or when does it end? So, and then उसी में आप देखेंगे, when you look at the courtrooms, you'll find cases being dismissed कि जी penetration अगर हुई है तो वो partial penetration थी कि वो full and complete penetration थी, which of course makes the difference between an attempt to rape and the commission of rape itself. So there are lots of issues, about language. We hear similar kind of things, whether it's the police, whether it's the judiciary, and anything in between, including society as well. And I think that there's this conjuring of images, of experiences which are basically inherent to the person that is being represented, whether it's the rapist or it's the woman, right? But a lot, and I really was when I was working on these papers, I was looking at Linda Alcoff's work, and how she discusses how we assume that the adversarial court system that we have in cases of involving criminal charges, the adversarial system, assumes that there is a neutral backdrop of the state again, and in front of which you have these two competing parties. The state is neutral, and then there's some kind of power balance between those two adversaries. And what is then, what eventually happens is the triumph of a certain version of the truth. And you can use the same facts to make different truths. You can make different stories using the same amount of facts. So I realized that a lot of these certain privileged locations from which people speak, they're very discursively dangerous, in the sense that it carries a lot of danger for the woman who is making a claim of rape, with all the things that are attached to her body, to her how she lives, the choices that she makes in life, and not just the woman, or the victim, but also then the rapist, which is the kind of things that we're hearing these days. It's an animal. It should be dragged through the streets. It should be hung, in a square somewhere for everybody to see. So there are a lot of these essentializing narratives around both. When we not just the issue of rape, I think everybody agrees that there's general agreement that rape is a wrong. It is also a crime. But what makes a difference then is that when is it not wrong? Or when is it not condemnable? Or what form of evidence or what kind of facts need to be presented in order to make it a believable, a rape? So those are some of the things that I grapple with in the paper, and the kind of things that I've been hearing over the past many years. Things like जिंदगी तबाह हो गई, अगर औरत की जिंदगी उसके साथ ऐसा हो गया तो अब उसकी जिंदगी जो है वो बिल्कुल तबाह हो चुकी है. Or if a person is accused of rape, then उसकी जिंदगी तबाह हो जाएगी. So we have to protect innocent men from false charges of rape. So how that we imagine the harm of rape. Different things around what choices women have when something like this happens. For instance, I remember there was this one time when there was a case of three sisters who were gang raped, and the policemen eventually, obviously initially they didn't do anything, but eventually it came down to them advising the women that you're already married, so this is bad what's happened to you, so it shouldn't be a problem really. You can actually go on in life without telling anybody about this. So why inconvenience yourself? They would say things like 2016 amendments in the law, 2006 amendments in the law, which made zina available offense, has increased prostitution in Pakistan. They will say things like बड़ा मुख्तारा माई बनने का शौक हो रहा है. अभी नाजिश ने जो मुख्तारा माई का केस के हवाले के जिक्र किया, whether it was an elastic in her shalwar or a bizarban in her shalwar. I also remember reading in the case judgment that she was a divorced woman and she was an embittered woman, and hence she decided to bring these kind of charges against the accused. A lot of things, you hear a lot of things, and I think a lot of it stems from our understanding of the ideal victim. What we understand, from what we understand of victimhood. When we say, what do we understand true rape to constitute? It has to be, for instance, you will hear things like she delayed reporting, so there must be something more happening here. If she's too prompt in reporting, then that also goes against her. If she doesn't appear in a wretched state, then maybe this didn't really happen to her because she appears normal, right? If she's not in a confused, her demeanor is not confused, she seems she doesn't seem disoriented, then it doesn't seem likely that this would have happened to her. If she's not accompanied by someone, then it's possible that she's making it up, she's come here alone. If there's no physical evidence presented, obvious physical evidence presented, then she may be making it up. So anyway, there's a lot of things that are said, which of course carry a lot of meaning, and then these things carry all the way through the system. And those same facts are then misconstrued and used against the victim to basically undermine her credibility and undermine her evidence in her own case. So I'll end it here. Maybe Benazir can take it forward from there.
Yeah, thank you so much, Sarah. That was very helpful. It was really helpful for us to hear more about essentializing narratives that you spoke about, and the issues of language that arise in and out of the court system, the subtext that you addressed. And that provides a good segue for us to talk about the law. Nazish also had referred to how things boil down to the different shiks, right? So Benazir, if you could enlighten our audience on Pakistan's basic law on rape and any other legal challenges that you wish to address at this stage.
Hello, thank you so much for having me. I think after Nazish and Sarah speaking, I'm not sure I have much to say, but yes, I totally agree with what's been mentioned, that it kind of almost, you strip everything down to the bare sections of the law instead of really looking at it from another perspective. And globally, there's been so much work already on that there could be a buildup within the judiciary. I mean, now, of course, there's a lot of work from people like Sarah and Nazish and others, Maliha Zia, etc. But even otherwise, I think there was space within our judiciary before them realizing that taking on from Pakistani judiciary, often our judiciary looks at foreign judiciary for a lot of precedents or case law or how things are conducted. They have in the past higher courts, and they could have taken a lot from there, which unfortunately they haven't. Before I start, though, I'd just like to make a correction. There's no act or draft law on violence against women. Under the previous government, the Ministry of Human Rights expressly sought a policy or guidelines on ending violence against women, including prevention and how to deal with survivors. And I drafted that, but it's been shelved with this government, and it's never seen the, we don't know where it is. we don't know which shelf it's catching dust on. So just want to make that correction. Okay, so in 2006, the rape law was moved, the provisions of rape were moved from the Hudud Ordinance into the Penal Code. A very welcome move. Women's rights activists and other members of civil society very much part of the movement to get it shifted from the Hudud Ordinance, which was where it was very dangerous within the Penal Code. In 2016, further amendments to the law were made, and I'll just go through them quickly. And a lot of them are actually quite good provisions. Yes, there's some still lapses within the law, but I don't think the law has been applied enough for us to start re-amending it and making it perfect. Actually, we need to apply the law first and use case law to perfect it further. I think we forget that judicial precedent also changes the way judges implement the law. So in the lower courts, we have seen that now a little bit of the law is being applied, and I'll go through some case law of the Supreme Court because I want to end on a slightly more positive note than I have been doing in a lot of the panels that I've been on recently. So the 2016 provisions of the law say that DNA testing is now allowed of both the survivor, victim, and the accused. Confidentiality of the survivor's identity should be protected, and those that out her identity can be punished. So there's a penalty attached to it. Penalties for police officers who do not fulfill the requirements of the penal code when rape survivors come to them the penalty for them has increased. Rape by police officers, there was already a penalty, but it's been increased now to the death penalty. There's also that there could be in-camera sessions. So in-camera doesn't mean the lower courts, I don't know, I'm sure all of you have been to the lower courts, but there's no provision of cameras, etc. I mean, in a lot of the courts that we go to, but in-camera also means that you go into the judge's chambers for certain bits of the evidence, and it's not an open court. So that's a really welcome development in the law. The other is that that they have attempted to, lawmakers have attempted to provide free legal aid, free legal representation to survivors, which I think is, we all know, is a barrier in how women access justice. And so police officers should be telling survivors that they have the right to free legal representation if a survivor has indicated that they've required legal aid. The police officer then provides her with a list of lawyers compiled by the provincial bar councils who the survivor can contact for legal assistance. And how you examine a survivor has been laid out. It must be done with her permission. There must be certain, a woman police officer present, and a relative of the survivor can also be there. And of course, it has to be at her consent. But I have to say, this is a 2016 provision, but there were already SOPs on how to investigate a rape survivor from 2013. And it's been extensively quoted in Supreme Court judgments. So there was already a little bit of groundwork that took place before the 2016 law. And I think, I'll just see if I've missed something before I move on to other bits. Yeah, I think I've basically covered kind of the amendments. I mean, a lot of the amendments are also increasing penalty and punishment for rape. For example, for gang rape or rape of a minor, death penalty has been included. Whereas before it may have been life imprisonment. I think we have, I mean, it's already been highlighted and talked about in terms of language. And actually, I think it's such a good point that Nazish brings up, that a lot of people are guilty of, that at the end of the day, regardless of even me and my limited experience in the court system and the criminal justice system, is that it almost always boils down to sections. So regardless of what I have in the back of my mind or know, you know, I'm conscious of the fact that there's a certain language and how to be appropriate with survivors. A lot of it boils down to the sections that are applied in an FIR, the words of an FIR, as Sarah mentioned, and the evidence. I mean, evidence is crux, and the fact that in the famous case that we know of you know, of evidence, whether she was naked or she was just not wearing a shalwar, and how kind of lawyers caught on to that. That's what lawyers are trained to do, to catch on to evidence where you feel the elements are weak, to then create discrepancy within the evidence. Because when you're trying to get your case across beyond reasonable doubt, or to create a doubt depending on which side, who you're representing, that's what you hang on to. And so the crux all lies on that fact that the evidence is sometimes not complete, not taking into account often that a survivor, when she is speaking to the police, even women police, or while she's even relayed the experience to within her own family, there'll be a lot of discrepancies. And actually, if you look at globally feminist perspectives of how judgments have been looked at, this is the one thing that there's often been talk of, that we need to understand the experience a survivor goes through. So what she said in the beginning may not correspond with what she may have said later, but that doesn't mean that it hasn't taken place, or she's lying, or you know, it wasn't as brutal as she's made it seem, or now we can question her character. So I think that kind of needs to be unraveled a bit more. But absolutely, at the end of the day, even as a lawyer, I'd say that we look at evidence. And when we see the other side, evidence as being weak, where were you standing? If you were standing in a certain place and there wasn't enough light, it means you didn't see the act, or you didn't see the person who committed it, or you couldn't, so this is how we're trained. So I really think, especially after what Sarah and Nazish have said, is that I think training for sexual offense crimes should be done differently than when you do it, for example, in law students, when they're taught how to look at evidence and how to cross-examine on evidence and how to find gaps in the other side's examination. For sexual violence, it should be done differently, because I think we forget we can't apply the same rules, and we often do apply the same rules. So unless you point it out to lawyers in the courtroom or even to judges, no one really picks up on it. The other thing that I'd like to mention, and I think I'm trying to, I agree with everything Sarah and Nazish have said, so I'm trying to add from a different perspective, is often what we don't look at in the courtroom or give importance to is the crux of the rape law lies on consent. And I think that is, how do we look at consent? How do we examine it, both from a legal perspective? And again, it goes back to evidence. A lot of it is evidence-based. And I think that is because the crux lies on consent. Often what's happened is, for example, give you an example of something in Islamabad that took place, where I was involved in a recent case in which the judge very simply concluded, first, he was very much with the idea that the survivor had been raped. And the other side, of course, creates a doubt that actually it was a consensual relationship. And he moves from one element of it being non-consensual to consensual without seeing what things lied in the middle. So, and it was complicated in the sense that, can you have a relationship in which when there is consent, and come to the point where where after a few months there is no consent? So how do you differentiate in terms of evidence collection? Because in a way, what you're saying is at one point there may have been consent, and later there wasn't any consent, but it was too much for the judge to comprehend how that transfer takes place, if that word is the right word, how that happened. And I think he was clueless about that understanding. He couldn't comprehend it. He didn't understand what that meant. And it went back, I think, almost to that thinking, and I think Sarah mentioned it, about character and being habitual. So I think that it went back, even though the 2016 law, actually one of the most progressive things that this law has been able to do is take away bringing in the character of the survivor, which is what you could do in case law. And actually we blame it on Zia's government, but it was there in the British times. It was brought in through colonial rules, where the character of the survivor could be brought into question within the courtroom. That now has been eliminated in the rape law. Regardless, the case that I'm talking about took place after the 2016 amendments to the law, and character was very much brought in, even though it was repeated to the judge that it's not an element that could be brought in, but a subconscious bias started existing. And then there's not enough evidence. How are you collecting evidence? How are you bringing it forward? Is it just the clothes? Is it just the mannerism? Is it just a blatant rape? But if there's other things that aren't so black and white, how do you build up that case in terms of evidence and consent? And interestingly, Denmark is now working towards a model of how they look at law from a consent and non-consent perspective. So I think that'll be an interesting kind of progressive view to look at things as well. Even though our rape law is very clear on consent, non-consent is rape, how it's implemented in the courtroom is very different and very difficult, even for lawyers who can convey to a judge when you have evidence or lack of evidence, for instance, or the FIR is not supporting the kind of argument you want to make, because at the end of the day, that's what we're looking at. We look at, and to convict someone without evidence is also against, due process. So I've spoken for too long. Sorry, you can just tell me to be quiet. But if you give me a few minutes, what I want to point out is this, that I think that the criminal justice system is crumbling to the extent that the police have major issues when it comes to sexual violence offenses. And the lower judiciary has major gaps, including court staff. And so I'm not just talking about judges. It's the process in which how the woman comes into the courtroom, how she's repeatedly required to come into the courtroom, etc., and how she's dealt with the staff there. And I think when we look at Supreme Court judgments, there have actually been quite interesting judgments in which they've been sensitive in terms of language they've used, or even high court judgments in which they've been sensitive. But actually there's 1.9 million cases pending within the judicial system. So do we want every case to get to a high court in which we can read it, examine it, talk about it, and then go to the Supreme Court to get the judgment we want? Or do we want trial courts where the actual basis starts, where everything really starts, to have a foundation in which they understand? And I'm really a kind of an advocate for not just looking at High Court and Supreme Court, but actually working with and understanding how lower judiciary works and how we can better enable it to kind of be survivor-centric. But a few things, and ending on a, like I said earlier, ending on a better note. In 2020, there have been about 3 or 4 Supreme Court appeals. So they've come forward, all to do with rape. One is Babar versus the state, Zahid versus the state, and Farooq Ahmed versus the state. And in that, there has been repeated discussion by judges to say decisions that talk about the SOPs that the police must follow when they're investigating rape survivors. So that those SOPs lay out certain things of how you are supposed to examine a survivor. So they're not necessarily referring to the 2016 requirements of the law, they're referring to the 2013 SOPs. And the other important thing, that the thread that comes out of a lot of this case law, is that time. Because often what's argued in court is that the survivor didn't come in time to report her case. And one of the things that's come out in the kind of thread, the common thread that's come out in a lot of the Supreme Court judgments has been, we cannot overburden the survivor and expect her, after all the trauma she's gone through, to immediately report. If there's other collaborative evidence, we can build up a picture and create evidence to make it strong enough to say whether rape has taken place or not. And time is not the only thing that we should look at. It's also gone on to talk about how, for example, in one case where an IO was a man, he shouldn't have been a man, and the SOPs of 2013 clearly say that it must be a woman police officer of a certain ranking. And she must go and speak to the survivor. And in this case, it was a man that went, and the clothes of the survivor were not handed over. And a lot of the information was not provided to the IO. And the Supreme Court takes into account that they were too shy, both the survivor and her mother, and embarrassed to hand over the clothes, and to provide all the information and to be open about what took place. And we cannot hold that against the survivor. So it's repeated again in 2 judgments, actually, from what I've seen, that we cannot increase the burden on a survivor that's already gone through so much trauma. So I think that's something welcoming. We should be, advocating and putting forward these judgments and looking at them and highlighting them further. But I think what the superior judiciary, with all due respect, has failed to do is hold to account the lower judiciary on this. The higher judiciary may be saying something that appeases to us or international standards or the law or constitution or international commitments Pakistan have made. But what they really need to be doing is reprimanding or holding to account the lower judiciary for who they are in charge. So it's not just the police, but also lower judiciary. That activism within the judiciary needs to take place within its own system. I think that's where real change within the judicial system can take place, especially the lower judiciary. Thank you. I'll stop there.
Benazir, that was excellent. Thank you so much. I really appreciate the fact that you not only highlighted the progressive changes that have taken place in our legislation and also in our judgments, but you also spoke about some of the institutional issues that we're struggling with, particularly when it comes to enhancing the capacity of our lower judiciary. And I also found extremely fascinating the evidentiary issues that you just raised, because those different evidence standards are, I think, something that Pakistani lawyers may be struggling with, but it's also something here that in the US we struggle with. And I'm sure there are similar struggles in the UK now with like the Me Too movement, believing in her, perhaps a different standard of evidence applies. And so that just would make for fascinating further conversation when I return to you. You also raised really fascinating issues over contests regarding consent, which I also want to raise when I come back to you, and also subconscious bias towards character. Those were all like extremely fascinating points that you made. And I'll come back to you in the next round. But now I think this is a good segue for us to move into concerns about reporting and issues surrounding reporting. Nazish, in a recent thread that you authored on your Twitter profile, you referred to many of the problems that survivors face when it comes to reporting what they've experienced. I'd appreciate if you could share more of those concerns for our audience.
I can. But I just quickly want to just kind of continue for just 1 minute, something that Benazir pointed out. And I think it's critical because we still haven't begun to grapple with it. And that's the idea of consent. Again, what language will you even take this to court in, and consent, not just in terms of rape cases, like for instance, even Pakistan in the legal system grappling with consent, even with marriages, is very, very recent. So, I mean, whereas your Nikah-nama clearly says that a woman has to say, yes, kabul hai 3 times in front of witnesses, a woman's consent was deemed enough for marriage as late as the late 90s. This was a case where it was because you needed consent of the wali. So you had a court ruling which said, no, you don't actually need the guardians, the wali's consent. That was the Samia something case, I've forgotten. So I'm just saying that got established fairly recently as well, that even for a marriage, it's not just the guardianship, a woman's consent carries weight. And actually we see a rise in the number of honor crimes in terms of women taking their own decisions for marriages, only kind of predating that judgment, where that kind of space opened up where you didn't actually need a guardian's consent. So I think it's going to be a little bit of huge effort we're going to have to make for this to trickle down, not just in laws, but even in terms of social attitudes to be able to understand what a woman's consent does. We have kind of seen GBV courts, gender-based violence courts. They're fairly new. We don't have enough of a time span to be able to evaluate them yet. But I think Benazir's point, I just want to reiterate that the importance of kind of having different frameworks to deal with sexual violence and sex crimes. As just last week, we had a lower court judgment where the judge said, well, now if this man, it was a rape trial, and he said, well, if he's raped her, he gave the guy the kind of space. He said, look, are you willing to marry her? And I'll, let you go if you agree. And the guy agreed. And then the woman agreed. So the rape trial got converted, and the judge was quite happy. He said, ye to sawab ka kaam hai, like, so I've kind of stopped this woman's life from getting ruined, because obviously the harm in this case was actually just the act of rupturing of a hymen. The harm was not violence in itself, because in that case, why would you, you won't suggest marriage to someone who's attempted to kill you, right? So it was seen in a very particular way. Like if someone has tried to assault you and kill you, you're not going to say, okay, marry that person. But it was okay in this case, because it was a rape case, and the harm in this case was only, penetration, in which case legitimize the penetration, and it's okay then. And I think this point is worth kind of reiterating the need for kind of accountability of the lower judiciary. Now in this, marry the rapist case, I'm sure if it's appealed, it would be overturned in High Court. But I think the point is really, Benazir's point is important, that there needs to be an accountability even at the trial courts, at the lower judiciary levels. And maybe this accountability needs to come from the higher judiciary or whatever it is, because these are the undocumented cases. These are the cases that are not getting into law digests. And these are the cases where the mess is happening. I mean, how many women are going to be able to go through a trial court, then appeal, go into high court, and maybe go into Supreme Court? You're talking about 8 to 10 years. And whereas they really need to kind of pick up the shambles their life is in and move on. So they're not going to stay into 3 levels of appeal unless they have a highly supportive, probably well-off family. People go into debt. That people are socially ostracized. They go into debt to even be able to attend all the court hearings. Even when the family does support her, I can tell you so many cases where, subah se raat tak they're waiting ke peshi hogi, they're sitting outside courts for days on end, for hours on end. People can't really even financially afford to do these things. And when they've gone through a 3-year trial court process, they're certainly not signing up for another 7. Whereas even at the end of those 7-8 years, there's a 5% chance of conviction. So, the kind of mess is so systemic that I think the judiciary is actually an important kind of locus for attention right now, because we have the laws. The laws were brought in by parliamentarians, of course, through the push given by, women's movements, or, even women from women's movement who actually went into parliament and then created the impetus for change in laws. But my point is really the politicians are still at some level accountable. Even with the police, there's a level of accountability. With the judiciary, we really have nothing to hang on to, from the time, small things. Like I remember when I used to work at a legal aid center and we were dealing with survivors of violence, little things like court gossip. I remember the court clerk used to say, no, don't file it today because, that judge, his wife left him and went off with a younger man. So if this case goes into his court, that's it. No one's listening to you. And he's going to rule against her. Now, I mean, this was court gossip. It made sense. We went by it, but it just also gives you an indication of what personal biases, how they kind of translate and how they carry over. Because these judges are, of course, kind of drawn from this society. We have a case of, the first conviction we have in Pakistan under the domestic violence law. It was fought by Sara Malkani, and she managed to get the first conviction. But even in that case, what the judge, if I remember correctly, the judge's comments were, well, this law is very strange. Like if a man has kind of hit his wife, why does it kind of lead to things like this? So I don't agree with the law, but because that law is there, I have to give a judgment in accordance with the law. Now, he was able to say this in a full court that I don't even think this law is correct, but I'm bound by what it is. So, the carryover of these judicial, they're a part of our society. They come from this society, and then they carry over all the baggage of the society into a legal system, which assumes that it's this sterile vacuum in which all these biases kind of stay outside and only the legal stipulations. But we know for sure there's a carry in. So I just wanted to make that point. And in this point, I've kind of forgotten what you asked. Reporting, you were talking about reporting. Okay, yeah. So, getting to the reporting stage in itself is a trial, right? So for a woman to be able to decide that this is a rape case, in this rape case, I'm going to formally file a complaint and go through the formal judicial system. So to be able to make this decision, she's already had to, in all probability, either fight off the family or convince the family. Most of the cases, and we kind of, all of us who work on these cases keep repeating this, that in about, majority, we don't have numbers, but an overwhelming majority of the cases, the rapist is known to the woman and probably someone from her immediate social circle. It could be one of her family members, a neighbor, a relative, whatever it is. So in all those cases now, just the decision to file an FIR is a huge act of resistance that requires a trial in itself. She has to kind of go through to get to that point. And then you try reporting. And then you have the police who refuse to file a complaint in most cases because rape is non-compoundable. So once the FIR is filed, that's it. It's irreversible, at least in law. So if there's any money to be changed hands, if there's any bribery, if there's any arbitration, if there's any room for rethinking, it has to happen before the FIR, which is why a regular practice is, and completely in contravention of the law, is they file what they call a kacha parcha. A rough, like they'll write out the complaint, but they won't convert it into a formal FIR, kind of buying time. And a lot of time the police officers say we're doing it for her sake, not because we want money, but for whatever the reason, it buys time. And often you require people to higher ups to actually intervene to even be able to convert that kacha parcha into a formal FIR. So a lot of times it depends on who you know, and actually a lot of times it depends on not just who the victim is, but who the perpetrator is or who she's accusing is. And the police have this kind of calculus, unstated calculus at that moment, that they have to kind of figure out, okay, who is this guy and what are the implications of filing an FIR against this guy? How is he politically connected? Is the DIG going to call us? Is the minister going to call us? Are we going to get a call from the Interior Ministry or the Prime Minister's office or one of the intelligence agencies? Will someone from the ISI call us and say, why did you file? So they have to kind of figure out all these things before they file the FIR. Of course, it's not supposed to be discretionary, but it is what it is. That's how it works. And it's after the FIR is filed does the formal system kind of kick in, and then each and every step of those is a problem. The crime scene investigation, Sarah talks about that there's no kind of idea how crime scene investigations are supposed to be done. The medical legal, I already told you, they have no clue. There's no training. There's a huge dearth of qualified MLOs in most parts of the country. They did kind of fix that in Punjab by ensuring that health officers have to go on deputation for 6 months. So they have to go in as medical legal officers. But then what happens in rape trials, we've seen that because the system is as such that they have to be posted there for 6 months, by the time the case goes to trial, the person who did the medical legal examination has now completed their rota, whatever, and now they've been transferred out. So that person could now be 500 miles away and is no longer there to kind of give this testimony on the assessment. So it's a whole mess. So that's the medical legal examination. And then, the police won't look for witnesses. They tell the perpetrator and the victim that go find your witnesses, aap bata dein, hum kisse baat kare. But they won't go and try to find third-party people who may have, evidence something, know something, so there's none of that. They'll just simply ask the woman that, who do you want us to speak with? And then they'll summon them. कि आप थाने आके अपना statement दें, वैन को भेज देंगे कि फलाने को उठा के लेके आओ, स्टेटमेंट यहाँ पे लाके दो. But there's no on crime scene investigation. There's no kind of way of finding new witnesses. They have recently set up in KP, I know for sure, a special course, for instance, on how to do rape case investigations, but how functional it is yet, how many have passed out through it, I don't really know. I don't really also know how far that has progressed in other places. It's a fairly nascent initiative, and they seem to be, the reason I think that we're better off than before is at least they're cognizant of the fact that there's a problem, that this is something we don't know. So I think that in itself is saying something that we're at a point that they'll say, okay, we don't really know how to do this, we're figuring it out. They haven't yet figured it out. We know systems bear in, for instance, when a woman often goes before a magistrate after the challan is filed and all of this process is done, and they change their statements. And they'll say, no, maine galat banda bata diya tha, it was the wrong guy, I couldn't identify him, or I was mistaken, whatever. And we all know what has happened at that point. Either she's been threatened, the family's been intimidated, or there's been an out-of-court settlement through a jirga or through a panchayat, or something has kicked in, and this case has fallen apart because at this point somebody has decided it's better to either settle it outside or to let it go. And in case after case, we've seen that the judges accept it. So the judges who at that point know something has happened, but they're willing to let it go because, it's like Benazir was saying, the system's already burdened. They're already hearing too many cases. They have this pendency issue. So fine, if this is going to Dafa, get it out of our way. If she's not fighting for it, then why should we fight for it? So there is this kind of almost this I don't know, passive aggressive behavior where you just decide to let this case go because you're inundated anyway, and the case kind of falls apart. If that doesn't, then witnesses resign. You have hostile witnesses, the same thing has happened, they've been intimidated or paid off or whatever. So cases actually attrition at each and every point, and very rarely do they get to concluding arguments. And when they do, that's another mess, right? So Benazir was pointing out, because there's no specialized training, we have public prosecutors who are absolutely clueless about this whole process. They're just lawyers who've just been told to take on the job of a public prosecutor. They don't have any training, and especially nothing on sexual violence, no clue on how to do these things. I mean, Benazir was saying that, even as a lawyer, but as a feminist lawyer, she has something, whether she argues or not, she knows at the back of her mind where this case is progressing from and progressing to, and what the context of it is. We don't have any of that happening in the cases of public prosecutors. And I think there is almost this lingering, where women are concerned, it started off in the cases of honor killing. We had actually, like you mentioned, the British colonizers, the inheritance of their law, the thing of, what is it called? Grave and sudden provocation, right? So it was almost a thing in the law that in honor killing cases, when a man sees a woman that he's involved with or married to, his daughter or whatever, if she's with someone, then there is a grave and sudden provocation that almost becomes a justification for him to then kill her. I think this whole notion of grave and sudden provocation lingers actually in all violence against women cases. And even in rape cases, there's almost this tacit understanding that normal men don't rape. Rape is nothing normal. It's nothing normal people do. So we have a society that has a lot of respect and regard for women. So why did this abnormality of a rape happen? So either, like Sarah was saying, men have become these ravening beasts. They're psycho cases, they're psychotic, they need to be in mental institutions, because why would a normal man rape? Or there is something that caused a grave and sudden provocation. So like a normal person was moved to rape because he was provoked into it. And that shifts the entire onus onto the woman then. That what did you do that caused a perfectly normal person in a perfectly normal society that doesn't allow for rape? Why did this rape happen? What did you do that provoked it? And then, the whole thing flips. And even though we now have, like it's been pointed out before, rape shield laws, where you're not supposed to bring up a woman's past, all of that comes into play. What did she do before? What was she wearing? What was she doing out at night? Petrol pehle kyun nahi check karaya tha? All of that. That a woman's kind of agency in any way constitutes that grave and sudden provocation that would render otherwise normal men into, these lustful beasts. And I think it's until we kind of interrogate the notion of normality and what constitutes a normal masculinity, or the codes of masculinity that kind of operate during a so-called normality, until we're able to problematize those, I think we'll keep going down and round in circles. So I'll stop now.
Wow, thank you, Nazis. That was excellent. You raised pertinent systemic issues that we face with regard to reporting and the procedural problems that rape survivors and victims face. So now I'm going to turn to Sarah. And Sarah, if you could also share with us your perspective on some of the reporting problems that you've seen rape victims and survivors face. And I also welcome you to pick on anything that Nazish and Benazir have said that you would like to talk about.
Yeah, I'll pick up first. Nazish, just to jog your memory, this recent case that came where, the marry the rapist judgment that was given by the court. In this case, the woman was also pregnant. Yeah, she had conceived. So that was one of the things that was under consideration. But if this has happened in the past also, that this option is given, and it's not just by the judges, you also see this happening in police stations. Yeah. I remember many years ago there was a case we were pursuing actively, working with the family, with the survivor, to try and get the police to investigate the case impartially. And when we showed up at the thana and at the police station, and suddenly we find out from the other room, the police walas call in the rapist, the rapist, to come in with his mother and his sister, and marriage proposal being made right inside the premises of the police station. So if the woman conceives as a result, or presumably if she was a virgin before this happened, and it was not a gang rape case, these are three elements that are considered where the option to marry is given. I also want to mention, apart from jirgas and panchayats and informal kind of settlements that happen because of the pressure to withdraw, and because of all the problems that people have to go through in the legal system, I also want to mention parallel systems such as the anti-terrorism court, for instance. Right, so cases of gang rape, they fall under terrorism laws, and then quite often the ATC is quick to pick them up I think the same happened with Mukhtar Mai's case. The same happened with the Kasoor cases. That it was the anti-terrorism court that picked it up. And what happens is that once the ATC, the anti-terrorism court, comes up with a verdict, now that is subject to confirmation by the High Court. And often what you find is that the high courts would then reverse the judgment that was given. And then they would give you various reasons why the case was overturned. Or if there was a conviction given, it was overturned. So you would have things like the chain of delivery of vaginal swabs, for example, to doctors. There was not clearly identified. There was lack of clarity on who was responsible for recovering said articles. There were little omissions of this nature and that nature, again, introducing doubt into the veracity of the claim that is made, and then leading to, quick dismissal. So even though cases that are taken to ATC, and the intent of putting gang rape into anti-terrorism laws was then to have quick verdicts and have quick resolution of such cases, but we know that they have also not served the purpose in terms of cases of sexual violence, because often because of deficiencies in police investigations and medical examinations, cases are overturned. I also want to mention we looked at Khyber Pakhtunkhwa facts, figures, statistics. I think this was about a year and a half ago, and we were looking at the kind of cases that have come to court, rape and gang rape, and also we looked at the number of appeals that were made in case the accused was acquitted, and we realized that the survivor, the complainant, would appeal against an acquittal in about 10 to 15% of the cases, no more than that. So, it is interesting then to note that why, even though if a alleged rapist is convicted, and there is an appeal process, and it goes through those three levels, where it goes from lower to higher to appellate courts, and then eventually to the Supreme Court, and in Mukhtar Mai's case also a review of the of the Supreme Court. Why aren't cases where men are the accused are acquitted, why don't they go to appeal? So there's a very small, and that's an area that we don't understand much about. Why aren't these cases then appealed? It's not that hard to imagine why they aren't, because of course the process is so grueling in the first place, that maybe that is the discouragement that is there in the system. But again, we can't say anything about that conclusively. I remember many years ago, I was working on a research study on forced marriages in Pakistan. And I was going around talking to police officials and doctors and, basically officials in the criminal justice system. And I remember one police official specifically saying that, actually not one, there were multiple who said words to the same effect, that whenever we get a case of domestic violence, the easiest thing for us to do is to summon both the person who's laying the charges and the person who is accused, and we bring them over to the thana and we get them to talk to each other, and within 5 minutes we know who's responsible or who's at fault, and what the case is about. So then very conveniently there are, under your criminal procedure codes, the power is with the police, that once, even though by law they are supposed to register the FIR first, get the documentation in first, and then launch into an inquiry, what usually happens is the reverse, that they would find out who the woman is, who the accused is, how powerful they are, who they are, how are they related, what's the story here, who would benefit from this charge going forward. So you would have those kind of discussions happening right before the FIR is even lodged. And even when there is a complaint that is registered, often you would find them putting cases as, classifying cases as class A, class B, or class C. A being the fact that it's a non-cognizable offense, B being that it's been falsely reported, and C being that it's an exaggerated claim. It didn't actually happen as is being described. I remember when we were researching, when I was writing one of the papers that I shared with you earlier, War Against Rape had gathered statistics from 2004 to 2011 in Karachi, looking at the number of medical legal examinations that had been conducted in rape cases, and looking at the number of FIRs. So we went to all the police stations in Karachi and we got information from all of them on the number of FIRs that had been registered under 375 and 376 of the Pakistan Penal Code. And we also went to the capital city police office and got data from there. These two did not match, by the way. And then we got in data from the medical legal, the three major hospitals where medical legal examinations are conducted. And we found out that about 1/3 to 2/3 of the cases actually never got converted into an FIR. Medical legal examination had been conducted, a complaint had been lodged, what Nazish just called kacha pacha, or a daily diary, jo police walon ki hoti hai. They would make an entry there, but it would actually never start the process of, proper investigation and then litigation after that. So this is just, taking from what has already been said about the problems with the system itself. But again, I would also like to emphasize that a lot of cases that we have dealt with, that I have been involved with over many years, and a lot of activist friends who get involved in cases, often we come into action when either the FIR is not being lodged, or it has already been lodged but there is no progress. The challan is not being prepared, the case is not being prepared to be presented in court. So this is where we come in. But there are lots of, again, there's a huge area where cases are not reported anywhere. And we have absolutely, no idea what happens in those cases and why they didn't get anywhere, or what actually goes on. So I think that remains a huge problem for us to really, going by the small number of cases or small proportion of cases that are reported, and then as they filter through the system, they fall through cracks in the system that are there at every level. Then you hardly have a few, handful of cases where you get to the conviction or you have some kind of judgment. But again, those judgments, unless you follow the case through and through, case judgments, case law will not tell you exactly what transpired and how, what kind of discussions were happening, what kind of pressures were there, what kind of decisions were being made. And often you would find that a lot of these decisions are, they contravene the law. There are things that are done that are not allowed in law. Benazir has already mentioned some of them. It's not just insertion of certain clauses in the Pakistan Penal Code in 2016, but also the repeal of certain clauses that apply to cases of rape, which one being the requirement for prompt reporting, and the other, using the pulling in the character of the woman to discredit her testimony in court. So, there are a lot of cracks along the system, and of course, all of these collectively then discourage cases from coming forward. I remember, a few the high profile cases that happened some years ago, and then suddenly seeing that within the same geographic area, say a few cities that we were tracking, suddenly the number of FIRs just went down dramatically because the verdict in one huge case, highly publicized case, came forward and there was no justice given. Right, and suddenly you see that the number of FIRs just go down. It could be unrelated, but I suspect, and I think all people who work on this issue know that unless justice is seen to be done in these kind of cases, in matters of due process, in matters of fair trials, in matters of thorough investigations, unless people see justice being done, you cannot break impunity. You cannot actually foster a culture where people are encouraged to disclose what has happened to them, and actually come forward with their cases. I'll just end it there for now.
Thank you so much, Sarah. That was extremely helpful. I think you continued many of the points that Nazish was also making regarding this issue of parallel justice, regarding these procedural challenges that we face that prevent the registration of the FIR from taking place. And also, I think you raised this pertinent issue that deserves further exploration regarding the acquittals that you mentioned from KPK, whereby acquittals aren't being appealed. So all of those were very interesting points, and I welcome Benazir to either comment on this thread and speak about some of these reporting and procedural challenges that Sarah and Nazish have been speaking about. We also have a question from the floor, like someone, one of our students has commented on our Facebook to ask this question. So I'm just going to put it out there. Benazir, if you want to answer it, you can answer it. Otherwise, Sarah and Nazish, if you want to take it also, you can take it. So Zain Said Siddiqui is asking, what about marital rape? Are there any laws to punish the husband involved in the crime? It's sad that our society hardly talks about it. So that's the question that we have from one of our students.
Okay, thank you. I think Nazish had said something really interesting, and Nazish, I'm waiting for your article on it, grave and sudden provocation, because there's so much in there, and I'm sure you're probably the right person, and others would agree, to write something on this, to start a debate on this, grave and sudden provocation and consent, actually. I think we haven't talked about consent enough, and I think there needs to be, both from a legal perspective, but otherwise also to discuss that further. I agree completely that there's so many cracks along the way, as Sarah has said, that's why at whatever forum I can possibly say that I do, we need to consider lower courts' judgments should also be recorded judgment. They should appear, within digests or some legal requirement for them to be published. They're already public documents. So those judgments are already public documents, but what we need is for them to be published in legal journals, because I think that'll, first of all, lessen the burden on the criminal justice system, but also allow us to see where that gap is, because we're always relying on the High Court and the Supreme Court, and we're not getting anywhere, just like Nazish mentions, which is absolutely correct. And I've had many clients, and often not even horrendous cases such as rape, but even within family courts, where if they feel after a certain trial procedure that they haven't got what we wanted, to try to convince them that let's go for appeal. They're like, we cannot go through that process again. We just can't put ourselves through something like that. And that's not even sexual violence or being violated in that same way. So I absolutely agree. And I think that's why I emphasize so much on the lower judiciary. But I think, and I think something radical here is, I think what we need to ask ourselves is the police the right forum for us to be approaching the formal system of the state to seek redress or protection or justice? Is that should that be the first point of contact? And is it the correct forum? I mean, I know that Sarah Malkani is an amazing lawyer, and she got this conviction for the domestic violence case. But I often ask, was that conviction possible because the police were not involved in the case? There was no FIR. Because when the survivor approached the police, they asked her to go for her medical legal examination. She went. When she came back to the police station, they refused to register an FIR. So the party went straight to the court. So we didn't start in that case with an FIR. And I wonder if we got a conviction, I say, as our collective victory, because the police wasn't involved. And I think we really need to ask ourselves, has that broken down? Is there to a point that we should not be relying on the police for this? I mean, I know, like the cases that I've quoted earlier from the Supreme Court, they were all convictions actually from the lower court. So there was certain type of cooperation from the police that went up to the lower judiciary. Lower judiciary, under the evidence that was provided, found the accused guilty, and then it was appealed up to the Supreme Court. But how many cases like that are there? How many actually make it? And how many, I think Sarah's mentioned something. Yes, they can go directly to, but often we go to the police. I mean, if a layperson is thinking it from a layperson's perspective, when you have an issue, you will always go to the police. Just to read out, I'm not sure Sarah's comment can be seen by the viewers. What Sarah has mentioned, and rightly so, that you can go straight to the magistrate. But really, you go to the police often. I mean, I've had clients who've called me up and to say that police wala hame tang kar raha hai, aap baat kar sakti hain usse, ya dusri side ne paise diye hain, police wala hame thane mein bula raha hai. You know, unless they know someone, for example, like a lawyer like Sarah or someone else, to say, okay, we can go straight to the system. How many people will actually go to a magistrate or approach the judicial system first? So I think that we need to ask ourselves. To be honest, there's huge issues going to the magistrate as well. You know, it's not hunky-dory there either. But I think we need to ask ourselves, and I think that's why that the gender-based violence courts in Punjab, and I agree with Nazish, it's too early to comment on them. I've seen some of their judgments, and I think very well done with the training that's taken place there. I just feel a little bit of a reservation in the sense that I think there could be a little bit more vigorous analysis in that judgment, in those judgments as well. I've only seen a few, so maybe I'm totally wrong. What I'm trying to say is, is the police relevant, considering in a way we've lost confidence in them? And there are cases in which they do good work, and there are individual police officers that are really proactive. And there's been an induction, I know in Punjab there has been, of young women police officers from a different type of cadre and a different type of education background. But really, I think, have we lost confidence, especially in certain type of cases, to approach the police? So we need to ask ourselves, is there another system? Should there be another system? I mean, maybe that's not the right answer. I don't know. But yeah, beating a dead horse, where are we going to get? Because I think there's such a deep bias within them. Like said earlier by one of the other panelists, that they also come from within our system, both the judiciary and the police, and they carry that burden and biases with them. So really, is that the place that we should be going to? I just like to add one more point. I think that the role of parliamentarians, I agree completely with Nazish, they need to hold the executive to account when there's a lack of implementation. And I think there isn't enough of that. I think they stop at lawmaking. And with this government, they've even stopped before that. So really, we need to ask ourselves, where are parliamentarians in this whole process, or lawmakers, or our representatives in parliament, in terms of holding to account executives that aren't doing their job? But I think that when I often say judicial activism, or that word has become quite notorious in Pakistan, is there is a lot to be said for judicial activism, but not in the way that we use it. And I think judicial activism is how judges look at survivors in the court system, how they control their courtroom, how they control their court staff. I mean, I've seen in rape trials in the courtroom where you can see court staff snickering while evidence is being provided, where information would be a bit sensitive, and survivors have really felt that, even though that's not, it's not a adjudicator that will eventually make a decision or decide something that affects them. So the attitude within the court staff, and I think that is the kind of really aggressive kind of training that the lower judiciary should be having, but also the superior courts need to ask the lower judiciary, what are you doing in your courtrooms? Why is it taking so long? For example, the Rape 2016 law requires, which I think is too short of a time, requires that the rape trial should be concluded within 3 months. 3 months is too short of a time. I think that was lawmakers being overambitious and trying to attempt to deal with that criticism that there are such long delays within the criminal justice system. But how are the higher judiciary holding to account the lower judiciary when that's not taking place? I know I've seen within Islamabad courts, family judges in the lower courts say to us, just to lawyers, कि आप प्रोड्यूस करेंगी अभी 11 बजे या कल आप आए कोर्ट में, क्योंकि हमें हाई कोर्ट पूछ रहा है कि इन केसेस में इतनी डिले क्यों हो रही है. And once I even heard a woman judge actually in Islamabad say to one of the parties that मैं आपको फाइन करूंगी अगर आपने एक और adjournment ली मुझसे. So I think that we need that trickling down from the top to the bottom, and that we don't see enough of. I know that Justice Aisha in Lahore High Court has done a lot of amazing work. She does a lot with women judges, and that needs to be replicated with all justices, holding to account lower judiciary and then moving its way up. I think we don't see enough. I had a few other points, but I'll keep quiet because I see lots of movement taking place here, and there may be questions from the floor, so I'll stop there.
For that, Benazir, that was extremely helpful, and I think in times of defund the police, it's a pertinent question to ask whether citizens' first point of contact with the state should necessarily be the police. And Sarah raised an important point through her message to the floor, pointing out that citizens can go to the magistrate as well for rape cases, but as Benazir pointed out, that can be hard sometimes. And Benazir also raised important issues related to training, important sort of reforms that can take place in that area. And I'd like to get back to her towards the end to seek in greater detail, try to understand the ideas that Barrister Benazir is presenting with regard to reform and training. We have some questions from the floor, and we had this question on marital rape. In case, I think Sarah, if you want to take that, and then we also have a question from a student regarding punishments, if anybody wants to address that.
Okay, so regarding marital rape, and I get this question quite often, that is it a punishable offense, and does it even exist, and so on and so forth. So just to clarify, marital rape is not a legally defined category under law. The main section of the Pakistan Penal Code that deals with sexual offenses, and they're various. There are over 70 to 80 different provisions in the Pakistan Penal Code that cover some aspect of sexual assault or sexual attack, and so on and so forth. But 375 of the Pakistan Penal Code, which specifically gives the definition for rape, and it defines exactly under what conditions rape can happen, or it could be said that it has happened, is that if it happens against the victim's will, if it is without the victim's consent, if that consent has been acquired by putting her in fear of death or harm, if the woman falsely believes herself to be married to the man, but the man knows that he is not married to her. And I think the last one, the fifth one, is if with or without the victim's consent, if she is under the age of 16. Now, just to give you a little background on marital rape, when the laws were amended in 2006, Zia enforced the Hudud ordinances in 1979, and then for 27 years they were in place, intact, and then, as Benazir mentioned, they were taken out of the offense of rape was taken out and put back into the PPC. At that time, when this law, the 2006 law, which gives you the definitions and conditions for rape, there was a lot of discussion on putting a qualifier or an exemption for husbands, for spouses, saying that it is against her will or without her consent if the accused is not her husband. But due to efforts of many people, that was never specified under the law. That exemption for husbands does not exist. And then, of course, as I mentioned earlier, how do you look at consent? How do you define willfulness? And what is against your will? You may consent to something which is against your will, right? So then again, it raises the issue of interpretation. That how are charges of rape, if they are brought against a husband, how are they interpreted? To my knowledge, all the years that I've been working on this issue, I have never seen a case of marital rape tried as a case of marital rape in a court of law. Usually what happens is that there's a case for domestic violence, or charges are pressed for domestic violence, and then as you talk to the person, the victim, they would initially tell you that he beats me up, he does this, he doesn't give me food, he doesn't let me go out. And then they will disclose, as you keep engaging with them, they will disclose more and more details, and eventually you will get to a point where you will also find out that he's been raping her as well, right? But again, re-emphasizing the point that there is no prohibition in law that you can't bring a case of rape against a husband. It can be done, but obviously a lot of it depends on how these laws are interpreted and applied. There are a few other things that I wanted to mention. I believe in 2009, there was a national judicial policy which was passed in Pakistan, and then it was amended 2-3 years later, maybe 2011, 2012, which was basically in reaction to the high level of pendency in cases, and that cases should be disposed of expeditiously. That the national judicial policy does not talk at all about the quality of judgments that are given. We've already repeated so many times during this conversation that we need to know what's happening in lower courts. The kind of reasoning, what is understood to be rational behavior, what is understood to be logical behavior, what is understood to be natural behavior for human being, how all of these things are constructed in lower courts. There's nothing in the judicial policy that says that the quality of judgments are to be looked at as well. What did happen as a result was that of this policy was that at the end of every month, judges of the appellate courts would require reports to be sent in, and the lower court judges telling how many cases did they take on, how many did they dispose of, and so on and so forth. So, and related to this is something that I mentioned in a discussion a few days ago also, that in the present law, as Benazir has mentioned, there is culpability for the police for defective or biased, investigations and biased kind of reports. There's culpability for jailers. There's culpability for medical examiners. These three different, cadres have been specifically mentioned that if they defeat the purpose of an investigation, they will be, subject to fines or whatever. In police's case, I think it's 3 years imprisonment as well, with or without fine. But there's no culpability for lawyers. There's no culpability for judges. The national judicial policy doesn't cover it. The law doesn't cover it. So in effect, what we have is a highly unregulated lower court system, where it's not just the judgments that are being created, but generally the environment of these places. I mean, it's an administrative issue as well. You talk to some of our friends who work with cases, who go to courts, and they will tell you that if it's a case of rape, and then there's the victim's lawyer sitting there, and the accused side, the defense side would also show up, and then there will be a group, a gang of 20-30 people who are collected in one place just looking on, right? And wondering what's happening. So it's not even, you could have policies that you look at the quality of laws, you can put in policies regarding the administration of the court system, but again, how do you control that environment? How do you make it women friendly, or how do you make it conducive to someone actually coming in and declaring that they were subjected to rape? There was one other thing which we've spoken about recently, Benazir just mentioned that, how do you get judges to look at progressive case law that has been given earlier in judgments. There are various judgments that say that the sole testimony of the survivor is sufficient for conviction if it inspires confidence, right? So, I mean, there's so many cases that say that over and over again, but then there's a however attached to it, right? Like, however, even though it is sufficient for conviction, but, when you look at this and this, it doesn't gel, it doesn't, create the kind of story that is more believable, that would make sense to a rational person in terms of the sequence of events. Benazir mentioned, the issue of judicial activism. And yes, there are negative connotations attached to that. I remember this was about 2 years ago. I was interacting with police officers, doctors, and prosecutors from different parts of Sindh. And there was this one very young, bright medical legal examiner from interior Sindh, I forget the city. And he said that, we have judges now showing up at our hospitals and, saying that why is this, a trace of blood there? Why are these sheets dirty? Why haven't you taken care of, the operation theater according to standards of hygiene and, infection prevention and all of that? So this particular doctor was extremely miffed. And he was like, they shouldn't have any business doing that. Why are they getting involved into the role of the executive? Again, as Nazir said, that the executive needs to be held to account, but who's going to do it? Right? So you suddenly had this wave of judges going into hospitals and going into schools and physically checking things. And on the other hand, while they were looking at, traces of blood and dirty laundry and things like that, they're not bothered to look at, registers, who's coming in when, which doctor is available or not available. This is one of the biggest challenges of getting medical legal examinations done in a timely manner in Pakistan. You just don't have the doctors. I mean, it's not just about qualified doctors. You don't have doctors, period. Because this particular area of medical study is not something which is highly regarded in this country. Forensic sciences does not get the kind of attention that it should get, whether in medical seminars or huge conferences where different medical research is being discussed, different issues are being discussed. This subject is completely kind of sidelined. And yes, there are certain precedents. Benazir just mentioned the Lahore High Court and certain judges taking things forward, banning certain kind of practices, or saying that I'll fine you if you get the case to adjourn again. There are judges that we are working with across different provinces. We find that are sensitive and cognizant of the issues, and are also extremely frustrated by the system because it doesn't get to convictions, right? So you actually talk to these two judges and you say that, is there some way, if we say we file a petition, would you, preside it? Would you hear it out? And then would you help us maybe set a good precedent? And that is happening. So, a lot of activists are now, they have used this tool in the past. We've tried to change the law has dramatically changed. But I think that there's a problem with case law saying that, you're not supposed to treat these kind of cases in this manner. How do you get that to translate at the Thana level, at the police level, at the medical center, the legal center level? It's all fine that all these things are there in the text, but it doesn't automatically get transferred in practice. And there's actually no process for that kind of transference to happen. That if there is a judgment, a good progressive judgment, how does it actually come down to becoming, common sense eventually, which it is not at the moment. So we have to figure out how that happens, or if it doesn't happen, how do we actually get that to happen? And the last thing that I wanted to mention was about trainings. So much money goes into this. So much money for so many years. And yes, there are various reports of certain cadres of police or younger police officers who joining the police force being more sensitive. But I think what is lacking here is that these different institutions, they don't understand each other's work. Even if they have a command over, or they have a set procedure for what they're supposed to do, they have very little idea of little mistakes that they can make, which can have huge implications for the case at a later stage or some other stage. So I personally, buy into that idea that you cannot just, if you're trying to sensitize the police, we agree that everybody, across the board, there's need for sensitization and, discourse and understanding what's really happening and how to handle these cases. You need to get all of these people together in a room and, have that dialogue that if a police messes up somewhere, how does that impact prosecution? If prosecution omits something, what can it call in purposively from the medical field to strengthen its case in court? I think those kind of dialogues and those kind of integrated multidisciplinary trainings are more essential than what we are used to seeing all these years. Clusters of police officers being trained and clusters of judges being trained. You've got different institutions. Police academies are different from the judicial academies. Nothing really for prosecution. Where do prosecution train? We don't really know. There is no one place where all three of them, let's say, if we were to consider, I would even involve the shelters in this. But if we just go by, medical, legal, police, and the judiciary, including the staff, the court staff, the judges, the lawyers, the defense, the prosecution, you get all of them in a room and get them to discuss this issue and go into the technicalities of then how does it, impact eventually the cases that go through this entire system. So, I mean, there's so many cases where, for instance, I've had doctors tell me that, the sample that the police wala brought, I couldn't do anything with it. There's nothing stopping medical examiners from going to the place where the crime is committed. But they tend to sit in their hospitals and wait, if they're there at all, they wait for the case to walk in. They don't bother actually going to the field and collecting forensic evidence, which they themselves know best about, perhaps, as opposed to the police. But that kind of integration doesn't happen, whether it's on job or it's during their trainings. And I think that's one last thing that I wanted to emphasize, because honestly, I'm sick of hearing sensitization trainings when these people don't understand each other's work and how it's all connected. That's it for now.
Thank you so much, Sarah. That adds beneficial perspective. Thank you for addressing marital rape. Thank you for addressing the gap between the legislation that we have and its implementation, and also the need not just for sensitization training, but for cross-disciplinary training, for training that is integrative of these different branches of the criminal justice system that rape victims and survivors have to interact with. So with that, I'll open the floor to Nazish and Benazir for any concluding remarks and reform suggestions. And I also invite the panelists, if they want to give an opinion on this. There is a question from a student who's commented on our Facebook regarding punishment, if people want to address that.
Yeah, I'll, Benazir, should I take the punishment question?
Please do. Please do.
The reason I want to kind of address that is because that's the new big deal, right? You have the Prime Minister and the government all gung-ho about hanging people from trees and chemical castration and whatnot. So which is why I want to kind of address this specifically, because we're talking to students. These are dead-end practices. These are non-starters really to begin with, because our problem is, and which is what we've been talking about here, is we can't get to convictions. So if a woman has been raped, she can't point to somebody and say, this guy is my rapist, and the police is not going to hang the guy the next day. She still has to go through the entire kind of trial process. And at the end of the process, someone has to be convicted in order to be punished. You cannot punish who you cannot convict. And the problem in our system is you can't actually convict anybody because of all these things that we've been talking about. So I think this is actually a real distraction to talk about chemical castration. I don't think they have a clue on what they're even talking about. It's not a one-time thing, right? It's something you have to do repeatedly. Who's going to do it? Is a man going to come to the hospital and say, okay, it's time for my kind of, twice a year dose? Will you send your lady health visitors to go and castrate a guy chemically? It makes no sense. And also in terms of these public hangings, it's been tried, tested across the world, doesn't work. So the point is, you need to fix the system and lead to convictions. And then we can talk about what should be the right kind of nature of the punishment itself. And I just want to quickly point out also that the higher the grade of punishment, the higher the evidentiary burden. Right? So if you're saying death penalty, then that means the case needs to be airtight. The evidence can have no question marks on it. It cannot be something that's sort of established, but not really established. So it actually ends up working against the victim in rape cases, because you can't bring in, sealed, airtight evidence, especially in cases where it's a woman, where she knows the rapist. Maybe it's, been someone in her family, in her neighborhood, raping her over years. Where is she going to get this evidence from? If it's something that's happened more than once over a protracted period of time, I'm just kind of just want to flag the whole issue of increasing the burden of evidence. About the police, I think Benazir's kind of raised an important point. I think my imagination is maybe a little limited in terms of we kind of deal with our daily realities. Maybe they can be an alternative in terms of first point of contact that we haven't even begun to kind of talk about yet. But having said that, I do want to also point out that let's not let them off the hook and say, oh, this is such a corrupted institution that it actually cannot be reformed. Screw it, let's find something else. I just also want to point out that there have been changes in policing. Specifically in Sindh, I can talk about it for sure. Across Sindh, you can speak with civil society activists, women's rights activists, who will tell you that in the past few years, maybe 4 or 5 years, we've seen a significant change that's happened in the police, specifically with regard to sexual violence. And there are gradations, right? So the younger, if it's a child, you'll find this police moving a lot more faster, because again, coming back to, there is no questioning of consent, right? So they're not saying, oh, was the kid involved? Did the child lead the person on? Did she kind of say yes and say no? So there's none of this kind of questioning. So they move very fast. In honor killing cases, there has been a provision in the law that if the police doesn't move, then they're directly culpable. So they've started moving on, even on rape cases. So we do see a movement. There is a couple of things. There's a DIG helpline, and I know there's one in Punjab as well, right? So there's a direct DIG 24-hour hotline that you can call in, where you immediately can report a case and you will find a response within the next 12 hours. In Punjab, I know they've put women in almost every police station now. In Sindh, they have this helpline. You have these WDD centers that have, deputed officers that are supposed to be kind of handling these cases. There's a WhatsApp group with all the police hierarchy in it. And they've also put all the women's rights activists on it. So in case there's a case that comes, it's immediately flagged and there's kind of instant action on it. So my point is really the system moves, and we can't say it doesn't move, because that also disempowers us. It leaves us at a point that we're saying, okay, might as well give up, do something else. This is not going to change. So my point is really that it can change, it does change, it has changed. And counterintuitively, and this is an actually horrible thing to say, but these are the realities we live with, you don't really find that many cases of people being raped and killed earlier on. They're being raped and killed now. They were being raped before, they were being killed before, but this combination wasn't happening. So what is it now that's resulting in, rapes that are resulting in immediate killings, murders as well? Is it some kind of twisted new kind of pathology to it, that the eroticism is to terrorize to the point of death? Or is it also that you can't really get away that much with rape cases because you can be identified? So if you rape someone, you just might as well have to murder. I mean, so counterintuitively, this might actually link with something that the police is doing that is creating this sense of lessening impunity for rape, which is resulting in murders. And that's a difficult thing to say. I have no research to back it, but just in terms of the cases I've worked on. So my point really is the system has moved in terms of policing, in terms of the law. We tend to talk a little bit more now, saying that laws don't get implemented, but I just want to also flag that for the laws to not get implemented, the laws need to exist. So just the fact that we have laws now which are good. Like Benazir gave a really good, quick primer of the 2016 law, very good. Even before that, we've seen steps towards improving the law. And these were really, really hard one steps. You know, it started off in 2006 when the Women's Protection Act got rid of the Hudud Ordinance. I don't know how many students are aware of the kind of ridiculousness that was imposed on the legal system through the Hudud Ordinances, where a woman who said that she had been raped, if she couldn't prove that she had been raped, she was sent to jail for adultery. And this happened not in one, not in 10, in countless cases. Throughout the 80s, throughout the 90s, jails across Pakistan were filled with women who said they had been raped and then couldn't prove it, so they were sent in for adultery. That law got changed in 2006. It took a huge effort of the women's movement over decades, but also it was a particular configuration, political configuration that worked. We had Femida Mirza heading the parliamentary caucus, who was very active on this. We had, Nafisa Shah, we had Sherry Rahman in parliament, all of whom had in the past been associated with the women's movement, including Mehnaz Rahman, who was with the PMLN, who had grown out of the women's movement, well, in the sense that they knew exactly what these issues were. There was a National Commission on the Status of Women, very active, headed by Anis. So it was a particular kind of coming together at that moment that made this law possible. Just quickly to flag that our current Prime Minister, Imran Khan, voted against the 2006 law. But having said that, it took the 2006 law to enable the 2016 law. And the 2016 law has moved us. It's a fairly progressive legislation. We don't need any more laws on rape. We need to implement them. But the implementation battle is fairly new as well, because it started post 2016, and slowly we've seen those kind of changes happen. Not fast enough, for sure, not efficiently enough, but I think that raises larger questions, maybe better handled by the legal community and students who are studying law rather than me. But it does raise a question in terms of, do laws change society, or do societies change the law? And, that kind of relationship between the two, that, it's a chicken and egg, and I'm sure it's not, there probably can't be a linear answer, but probably in the interstices of the two, we need to kind of figure our way through those.
Thank you for that, Nazish. Thank you for also connecting this current movement with the women's movement. I'm glad you did that. I'm going to now turn to Benazir for any concluding remarks or reform suggestions that she may have before we wrap up this session.
I won't talk for long, and just tell me to keep quiet if I have spoken for too long, because sometimes a tendency to rant. I'm glad Nazish said that things have improved and moved on, and maybe I am a bit impatient. And that also goes back to the point that training has helped. I mean, I know there's been such extensive training, and like Sarah said, I'm sick of hearing about training, sick of being involved in it, sick of being part of it, because it seems like there's so much training of both of judiciary and police, and you see no real movement. But I'm glad that Nazish said that in Sindh things have moved. I mean, I also feel like, has it moved enough? And maybe that's again my impatience a little bit, with the population boom that it has, the few cases that do come to light, or there have been convictions, or the police have been proactive. Is it enough, considering the scale on which violence takes place? So kind of, I'm not 100% sure. But also, is the police serving, is the police serving, but it doesn't address systematic issues. It doesn't just address the fact that structures don't exist. So we use social media for highlighting cases. I know that's not the only way. The WhatsApp group that Nazish mentioned, I know there's one in Islamabad like that as well, in which there's police and rights activists. So they'll bring to light cases to police, and then police act on it. And it's great, this kind of networking that's taken place. But I mean, is it catering to everyone? Can I walk into, as an ordinary person, as an ordinary citizen, can I walk into a police station and get what I want? I mean, I think we need to look at cases like in India, the Gulabi gang, and the kind of socioeconomic background of women that came together is a vigilante group, but of a certain economic class of women that came together who basically almost a preventative vigilante group that look at domestic violence and violence against women. Is there space for a grassroots movement that doesn't really exist? I mean, one of the richest, I think, movements in South Asia have been in Pakistan with the women's rights movement. My only thing is I think sometimes it's elite women talking to other elite women for everyone, for all women. I'm not being critical here. I'm genuinely in awe of them and but thinking aloud. Is there space for some grassroots activism that we don't often see? That in Gulabi Gang there is kind of an aspect of it that doesn't really exist in Pakistan. Maybe it's my frustration that I say we should give up on the police, but for example, at one point when we have gender-based violence courts, we've also given up on the mainstream SIP system to have created that system because there's too many gender-based violence cases in which ordinary courts either can't deal because of the burden of cases they have or don't have the ability or capacity or resources to deal with it. So, is there that is also a space in which we're saying the ordinary court is unable to deal with, and so we've moved here. But I'm glad that Nazish has said that there has been movement, which makes me think that training is important. But one thing I just want to say, when I talk about judicial activism, like Sarah said, they've been going into hospitals and checking things. I mean, that's not the kind of judicial activism I mean. I think that's an overreach beyond their jurisdiction and something they shouldn't be doing. But holding your own house to account is definitely part of their role within the higher judiciary, to hold lower courts to account. And when I talked about the Islamabad judges in the Kacheri saying, okay, आपने केस को adjourn नहीं करना या आपने अपना evidence present करना है at the next date या इतनी देर क्यों हो रही है, these are all prompts from the Islamabad High Court that require the lower judiciary to be more proactive on adjournments. So really what we're saying is that what I'm saying is that the higher judiciary needs to hold its own to account. And it's very much within their ambit to do that. And the other thing about judicial activism is, and you'll see a lot of this work in South Africa, where judicial activism is taken in violence against women cases to say, if evidence is weak, or things haven't come together, of course they're in a straitjacket if evidence is weak, or FIR, in the FIR, the right language hasn't been used, weak language has been used, medical legal is also kind of, ambiguous, or the right sections have been used in an FIR. It's at that point for judicial activism to come into play, where the judges are conscious enough to understand that even with these weak elements, how can we put it together to see if there is a case in terms of violence or someone has been wronged? That type of activism doesn't exist. And that is when Sarah says the training should bring everyone together. It's actually the judges that can bring all those elements, and they're required to. Actually, their training as judges are required to bring pieces of every puzzle together, both from the prosecution, the defense, the police, medical legal, everything together, and assess the picture as a whole. So my emphasis over and over again, and I'll repeat it at the expense of repetition, that is lower judiciary, there must be a focus and a rethinking of how the lower judiciary is looking at sexual violence. And the cases that I quoted from the Supreme Court 2020, they were all interestingly convictions from the lower courts that either the High Court had overturned or there'd been some other issues that reached the Supreme Court, but they'd all been convictions at the lower court. So really, but again, going back to what Sarah has also said, that there's so many cracks by the time we actually get there. And then if we do get a conviction, there's such few cases. How do you create that momentum within the lower judiciary to bring those elements together. I don't see, I mean, I think it's a great idea that Sarah says that everyone should come together for training, how you have a knock-on effect if one doesn't do its job, how it affects another pillar. I don't see the judiciary sitting with the police in a training. I really don't. But I think if we could do in the training of the judiciary to see how they can bring things together, you know, how the kind of questions they ask, because, and you see that often, like in the Asia Bibi case, in the Supreme Court, it was the judges that prompted her lawyer to come up with certain things that the lawyer themselves weren't prompted to do at that point. And I think to awaken that within the judges on sexual violence. So that really made me think. It's the kind of prompting a judge can do. That's the kind of activism. When I say judicial activism, that's what I mean. Yeah. And I mean, to the extent that to ask the police why the report hasn't come, when it will come, how much the time period is. That, I mean, that kind of activism, I think, is very necessary. We don't often see it. There's a complacency within the system, definitely within the police, but also in the judiciary. And I think we need to overcome that. And it's all well and good that there have been one or two good police officers or one or two good police or good judges. That doesn't make a system. So we really, what we need to do is that collective questioning of the system and ask the legislative branch of government why they aren't holding the executive to account enough. And ask the judiciary, higher judiciary, why they're not holding the lower judiciary to account enough. I think I'll conclude on that. Thank you.
Who's going to hold the higher judiciary to account?
Sorry?
We've seen kind of
absolutely. That's a very good question. Very good question.
The Supreme Judicial Council hasn't done much either. So that's another debate. Sorry.
Right. No, thank you so much for that, Benazir. Thank you for highlighting issues related to judicial activism, for explaining what you meant by judicial training. I also found interesting, I don't want this point to be lost as a legal, somebody who operates in the legal education sector, what you said about training lawyers also. Sort of rings close to home, and perhaps that's also an area where we can look at making changes in law school and beyond law school as part of continuing legal education. But thank you for that, Benazir. Thank you, Sarah. Thank you, Nazish. Thank you, Fiza at the CEJ for organizing this. I'm extremely grateful for your time. I know you're very busy people, and I know for Benazir, for you, this was extremely short notice. So thank you for making time for us. We at IBA are grateful for the perspectives that you've shared that have been enlightening, that have shed light on complex, nuanced issues. And we look forward to keeping these discussions going. Thank you so much, and have a very good evening in Karachi and a good afternoon in London.
Thank you. Take care.
Thank you.